Contracts sometimes grant one-party discretion over whether or when to perform certain acts. In Nemec versus Shrader, we explore the intersection of such discretion and the implied covenant of good faith and fair dealing. Joseph Nemec and Gerd Wittkemper, officers at Delaware corporation Booz Allen, owned shares of the company's common stock. Their ownership was governed by an officer's stock rights plan, under which a retiring officer had a put option allowing the officer to command the corporation's repurchase of his or her shares for book value at any point during the 2 years following retirement. After 2 years, the corporation had discretion to command repurchase at any time, also for book value. Book value equaled the corporation's net assets divided by outstanding shares, and therefore varied over time. Nemec and Wittkemper retired in March of 2006. In 2007, Booz Allen negotiated to sell a portion of its business to the Carlyle Group. The sale, anticipated to close in March of 2008, would significantly increase share value, making it advantageous for Nemec and Wittkemper to retain their shares until closing. But the deal didn't close until July. In the meantime, discretion to repurchase Nemec and Wittkemper's shares transferred to the corporation. The corporation's directors exercised that discretion in April, meaning Nemec and Wittkemper received only the pre-deal share price. When the Carlyle deal later closed, the extra $60 million that Nemec and Wittkemper would have received instead went to the remaining shareholders, including the directors. Nemec and Wittkemper sued the directors, alleging breach of the implied covenant of good faith and fair dealing and of the fiduciary duty of loyalty. The directors moved to dismiss, arguing the claims weren't viable because the repurchase was authorized by contract. The Court of Chancery agreed and dismissed the claims. Nemec and Wittkemper appealed to the Delaware Supreme Court.